Your Lordship, indulgence, Your Lordship.
No,
There's one matter in part 2 which was fixed for today.
yes.
If this matter may kindly come up after a week, Your Lordship. I'm not feeling very well today.
Acha, that dumping matter, I guess,
Yes.
right?
Yes.
After a week?
After a week.
Okay.
Huh.
Item number
9.
9 of part 2. One second. Yes. This is Chairman, Managing Director, Bharatiya.
Yes, Your Lordship.
In item number 9, you write, heard Mr. A.R. Malhotra appearing for the
Appellate.
appellant, as well as Mr. You are? You are
CL
appearing?
Fakzola. CL Fakzola.
Acha. C. Lalfang Juala.
Yes.
Acha. Appearing for all the respondents?
No, plaintiff respondent. Respondent number 1.
Respond number
1.
1. The plaintiff.
Plaintiff.
Yes. And the others are informed?
The others are informed, and in fact they have no.
Yeah, contest.
They will not come later and object, right?
No,
You have informed?
it's against the appellant and me.
It's mainly against the
Yeah,
plaintiff,
yes.
yes. So and so, Mr. Malhotra prays for a week's time. A week's time to conduct the case. The prayer is allowed. List the matter after a week on a date fixed by the registry.
Obliged.
I'm
Daily list for motion item 1.
These item 1 to 13 are all related matters, I
Yes,
guess, right?
Manoj, those Mahindra matters.
So those all Mahindra matters.
Yes.
Where so many amount of money
Yes.
was embezzled.
Embezzle.
Okay, first one is what? First one is?
My lords, here in item 1 is one of the co-accused car dealers. But my
car
lords,
dealer.
I'll just get straight to it. I'm seeking to withdraw this, my lords, petition with
This
liberty.
is actually for
Quashing.
setting aside of the second FIR.
Yes, my lords.
Why you want to withdraw?
Yes, my lords. My lords, I had fairly, I'll concede, my lords, I had not impleaded the complainant. So, my lords, there was a
Oh, you want to withdraw and file it
file
afresh?
fresh, my lords.
You have not implemented the acha.
Yes, my lords.
You have not implemented the respondent because he is the complainant. Complainant is Mahindra.
Mahindra.
So Mahindra is not made a party here.
Either, my lords, the learned counsel, I won't object to him, his impleadment if he seeks so, and he can file his written objections. Either that can be done, or, my lords, I'll take it and file it afresh. Those two options are there, my lords.
I think taking it back and filing afresh
Fresh,
will be better.
my lords.
Instead of again impleading,
Yes.
you have to file an application, I'll have to allow, then
Correct.
again all those. Okay. In item number 9, you write, heard Mr. Jordan, so and so. And the learned PP for the state of Mizoram. It is stated by the counsel appearing for the petitioner that inadvertently the complainant is not made a party in the instant criminal petition which is filed for quashing of the second FIR. He as such prays for withdrawal of the same with the liberty to file a fresh application. Full stop. Prayer is allowed. The matter is, the case is dismissed as withdrawn. Okay.
Item 2.
Item 2.
With liberty. My lords, liberty, I hope my lords has done.
Here also.
No, my lords, in item 1.
With the liberty I have said, with
yes,
the
yes.
liberty to file a fresh application.
Wait for
Yes.
it.
And number 2?
My lords, in number 2, here, my lords, we are challenging the bail conditions. These are onerous. 50
Yes.
lakhs.
50 lakhs.
Yes, my lords. Today, my lords, I have to fairly concede one thing. Mr. Zakir Hussain is the prime accused in the whole, my lords, scam which they have alleged. Now, my lords, there are 3 FIRs against him. One of the FIRs on which, again, onerous conditions had been set is coming up at item 12.
Okay.
And my
Today
lords,
only?
here only, today's list, my lords. Here, my lords, again, similar bail conditions have been set. And I'm seeking, my lords, I understand it is the first notice stage. But if they can be heard together today itself, my lords, he's been incarcerated for 1 year, more than 1 year since
He's
his arrest.
inside.
My lords,
He is inside.
he's inside, my lords.
He's otherwise he was given bail,
He's given bail, my lords,
but then
in all 3 FIRs.
because of his onerous condition, he is not
He
able
cannot,
to come
my lords.
out.
He cannot. All his bank accounts have been seized. Whatever properties, movable, immovable, they've been seized, my lords. There's nothing he can do.
And there are applications for cancellation of bail.
Yes, my lords, that is there. And my lords, I must point out, in that particular application which is relating to one bail order, that is criminal petition number 13, again it's in the list today. There, my lords, stay had been granted, stay of the bail order, but that was still a particular date. That was not extended. And if today the complainant seeks that that should be extended, there is a direct judgment of this Honorable Supreme Court saying that, my lords, stay is not ordinarily granted when bail is granted, my lords. That citation is also there, my lords.
Okay.
So, your lordships, either your lordships can issue notice in this, but again, my lords, I would seek that it may be heard. This on a short point. Bail has been granted, my lords.
So if I decide in the other application that it will not be cancelled,
Yes.
then of course I can enter in this petition also.
My lords, that is there. In fact, if your lordships modifies the bail conditions, your lordships can still take either views if the criminal petition number 13 is still pending. If it gets cancelled, my lords, I'll return. I'll have to return and again seek.
But then giving relief in this petition will not again be of any help if I cancel the bail.
Correct, my lords.
So let me hear the other matters first, then I'll take up this.
My lords, as your lordship says.
With, actually together.
For admission, item 3.
Yes, regarding lordship, this item, actually now, my lord, all the matters related with Mahindra, my lord, as I submitted earlier, I am being led by a senior counsel from Delhi, my lord. So if we can have it on next week, my lord, on
Oh, you are praying for an
Wednesday, my
adjournment
lord.
then?
Wednesday, my lord, if possible.
This one, item 3,
All the matters, my lord,
all the matters.
my lord,
3 to 12 means
13.
counsel from Delhi is coming.
my lord. So if we all can take it up on
Okay.
next Wednesday.
In that case, I think I can take Mr. Jordan's matter, right?
My lord, I think so,
Yeah,
Because
yes,
this may
Fine.
get again delayed, right?
my lord.
And I think there is a recent judgment by Honorable Chief Justice Gawai saying that onerous condition is like
Yes,
rejecting the
Madam.
bail.
Yes, my lords.
I've read it in live law, I
Girish
think.
Gandhi. If I'm not wrong, Girish Gandhi. I'm not sure.
Huh,
my lords.
huh.
I
I read it in the live law. It's almost like giving no bail.
My lords. There also they said, my lords, if the surety is also creating a problem, that may
Yes.
also be considered.
That I can see the judgment.
just-
So what I can do, Mr. Malhotra, I can take up his matter because these matters can again get delayed. And for that, he is inside the jail. But then there is a stay, but then stay is not
Extended.
extended. So as such, as of now, there is no stay.
There's no stay.
Just one question. Last week, your lordship said that I may recuse myself.
Yes, my
That day I said.
Yes.
No, why I said is because Zakir Hussein's bail was moved by my brother. Mr. A.M. Bora is my brother. I tie Rakhi and also he is my
Yeah,
brother.
okay.
So I thought. But then it is seen that there are other bail orders and even for cancellation, my brother does not appear. So I think I can take it up. I
My
don't
lord.
have to recuse.
Fine.
So I spoke to him also. Then he said that not required.
Then your lordship,
Next Wednesday, my lord.
Next,
Wednesday, my lord.
next Wednesday,
My lord.
your advocate will come.
Hope so, my lord.
Okay. Then, right, item number 2 to, or the
13.
same order will. Oh, Wednesday is actually a division bench day and we have some criminal appeals also. I'll have to hear.
Then Tuesday, my lord.
Tuesday is also a DB day. Either Thursday or Friday, again I'll be going. So,
If your lordship
Thursday, if you can. Thursday?
Actually, my lord, Tuesday,
Tuesday 가지고 fix 사이다.
Oh. Oh, Tuesday also. Either Tuesday or Thursday.
Tuesday, my lord. Then.
Tuesday one boy class.
Oh, there are already 2 hearing matters fixed for Tuesday. These are appeal. Criminal appeals, right? This is?
One is criminal appeal and the other is writ petition criminal.
Oh, one is writ petition criminal, I think Mr. Malhotra
Yes,
is
yes.
there, and criminal appeal. So Thursday, Thursday again I'll have to dictate the judgments and I'll have to go.
I think, my lord, your lordship might like to take short matters only on Thursday.
Friday I'll have to go back
That's
to
why, my
Guwahati.
lord. Exactly. So we'll take it to either, my lord, even if it's DB date, Wednesday, I think we can accommodate somehow.
We can, but then there are, because Justice Kalita will come and there will be more DB matters on Thursday, Wednesday. So let us see, I'll leave it to the registry. If there are not much matters, then it can be listed.
No, my lord.
Next week,
Next
a
week, my
date
lord.
to be fixed by the registry.
No, my lord, I have to be
Oh,
sure
acha.
on the date because
counsel
the
has to come
council
from
is
Delhi.
coming on a date which I have to know it now, my lord.
Ah, yes.
Thursday.
Thursday,
Will it be a problem, my lord, for you if we have it on Tuesday, my lord?
Tuesday.
I think actually Wednesday is DB day and Tuesday is not normally a DB day, my lord.
Acha, acha. Last week I had, so I thought, I'm told
So
that.
we'll have it on Tuesday, my lord.
Okay, then Tuesday. Okay. You tell him to come then, on Tuesday.
Oblige.
Okay?
Your
Oh,
Chuba.
Tuesday there are other matters. You said there are other 2 hearing
My
matters
lords,
already
both of
fixed.
us on the other side have
That we
fixed
can.
matter.
Wednesday, your Chuba, time permitting, we can try on Wednesday.
But then his counsel will come, time will not permit, he has to go back, right?
Thursday,
Thursday, I have no instruction.
yeah.
So I
So
said,
Wednesday,
Then you try it on next week, next to next week.
no, my lord, please, because next week, my lord, bench is not certain, my lord. Now
No, there will be
there
bench
are-
for certain.
Justice Kalita Abdona.
Yes.
Justice Kalita.
And another problem, my lord, that is my counsel, my lord. So we'll have any date, my lord?
No, try it on next to next week. That
No,
will
my
be
lord,
good.
please, next week, my lord.
But then we can give it a try on Thursday then.
Thursday, my lords.
Okay?
Do we have, regarding the fixed matter for Tuesday, my lord, I think we can have it on Thursday, my lord. Now since they are here.
Because dictation of a judgment of a criminal appeal takes hours, no? So, Thursday.
My lord,
Let the matter come up on Thursday, all the item number 3 to 9, on the prayer made by learned counsel appearing for the petitioners.
My lord.
Yes, petitioners. They list the matter on Thursday next. Okay.
Yashuba, I believe there's one other matter which has
Yes,
not
sir.
been listed today.
yes, Lord, sir. There's still one matter left out, my lord.
My
If I'm not
God.
mistaken,
There are so many matters, another one.
Another one is
they're all Mahindra, my lord. Criminal petition 14 of 25, Lord, sir.
Acha.
I think that also has
It
to
is
come up.
It is stated by the council, appearing for the petitioners. There is one more analogous matter which is not listed today, along with the other matters. The matter is numbered
14 of 25,
14
2025.
of 2025. Criminal petition.
Madam.
Criminal petition 14 of 2025. List the matter along with the other matters that are on board today. List it on Thursday next.
Oblige, Lord.
Two to nine, and there will be another one. 2 to 10. Oh, good. They are also all analogous, all Mahindra. All. 2 to 9, right? All the matters are analogous. Yes.
My lords, 2 to 11 actually.
Oh, 2 to 11, 2 to 11. Yes. 2 to 11.
2 to 11, my lords, and
12 also.
12, my lords, is what I'm seeking your lordships may entertain today.
Oh, acha. This is also on bond conditions. I mean,
Yes.
acha,
13, my lord.
2 to
13.
my lords, 2 to 13,
13.
excluding 12.
acha.
Yes, my lords.
2 to 13 excluding 12. I mean 2 to 11. Oh, 2 to 10. 11 and 12 is your matter.
I'm sorry, my lords. It would be 3 to 11 and 13. 2
No.
and 12 is my matter.
11 and 12 are connected.
My lords, they say it's been written here with, but the orders are different. It's a different proceeding. One is for quashing. Second.
No, but then in that case I'll have to again untag it. I mean, because it is already tagged together.
My lords, the last order actually seems, in my understanding, it is not tagged. Somehow it's come in the cause list as such.
Oh, it's written with others.
Yes.
Is it tagged? It's tagged, I'm told. So we'll have to detag it or what? Untag it before I proceed to take up this matter.
My lords, again, both are different petitions. I understand it might have been tagged.
Because the parties are same.
Parties are same.
And 11 is meant for what?
11 is meant for, my lords, quashing of the second FIR.
this quashing of the
Yes.
second FIR, and this is for onerous conditions.
Onerous conditions.
So they tagged it because the petitioners are same.
Yes.
But then the other matter is separate. Item number 2 is separate.
Yes, it's a fresh matter, my lords.
Now, one thing that the other matters I'm hearing on Thursday,
My
so
lords.
not many days are left. So now if of course, if after hearing, if I give some relief, then he will be able to avail the bail,
Yes.
and for a few days he'll be out. Or shall I take it up altogether?
My lords, given that the nature of some of these petitions are quite varied, some are for quashing, some are for quashing of the FIR, some is quashing for the bail, and different parties are involved. Somehow my lords, this is my humble submission that main matter might also not be heard, my lords. There's a chance because these are all different accused.
Ah. So fixing it on Thursday will also be difficult. It might again spill over to Friday.
That, my lord,
Try it next to next week. In the meantime, I'll hear his matters.
no, my lord, I think there are short issues involved here, my lord.
But then still, I can see the file
And
so
my lord,
many.
if we take up one, my lord, if we take up one item, that will automatically, I think, cover all the matters. They are all similar matters, actually, my
No,
lord.
I'll have to
No, my
go.
lord, yeah, there are,
See, there are so many accused persons.
no, my lord, there are still,
Some doctor, something, then
that,
Proloy.
my lord, I agree.
Ah.
I agree, but still, they are similar issue, my lord. If we take up, for example, now, item number 3, 13, my lord. This is only for cancellation of bail order, my lord. If your lordship decides this issue, then 14, 15, 16, all will all be covered, my lord. So I think it's a, you can take it as that
You
way,
can,
my
you
lord.
can
Very
do
simple
it
way.
a week. You can do it next to next Monday. You get an entire week, and then the matter will be heard at length, and it will be disposed of. Justice will be done. Otherwise, this will spill over to Friday. I'll have to leave for Itanagar. So
I hope not, my lord. It
Very
will spill over,
difficult.
my lord.
let it be
Let's,
fixed
let it.
after a week. And in the meantime,
Let's just have it on Thursday, my lord, and then we'll see, my lord.
no, again the Delhi Council will come. No, it's not fair on my part to not take it up, and then he'll have to return. So I'll fix it up on next to next Monday, and then it will be heard at length. Justice will be done. Otherwise, it will be difficult. And what will be the date then? 23rd. 23rd. You do it, and there will be no paucity of time then. So fix it. I said it on Thursday now. So fix it on 23rd of June, 2025.
Then in that case, my lord,
Then
actually, my lord, there are no difficulties
you
involved. my lord.
you speak to your counsel.
My lord.
So whenever is convenient to him, let me know.
My lord.
I'm hearing the matter.
My lord.
Okay. This is It is still not taken. So item number 2 is here. 2, okay. Okay, Mr. Jordan.
Lordships is taking up item 2, my lords. My lords, here in item 2,
Just a second. Yes.
Yes, my lord. Here, your lordships, I'll take your lordships straight to the impugned order at page 24.
24.
Yes, my lords, 24. This is the bail order, my lords. And the
Yes.
effective part I'm challenging is at page 29. Accordingly, my lords, it starts. My lords, here,
Accordingly.
the effective part of the judgment reads, accordingly, this petition is allowed subject to necessary conditions to ensure the continued cooperation of the petitioner accused. And it is ordered that if his detention is not necessary in connection with any other case apart from crime and economic offences, Police Station CID crime case number 3 of 2024 dated 29 March 2024, the petitioner accused shall be released on bail on his furnishing a bond of 50 lakhs, duly guaranteed by a suitable surety. The bail is subject to the following conditions. The petitioner accused, Mr. Shri Zakir Hussain, shall report to the CNEOPS CID crime every day at 9 a.m. or at such frequency and time as may be directed by the police, and he shall follow their instructions. Number 2 is, my lords, petitioner accused shall not leave the jurisdiction of the SP CID Aizawl or relocate from his address presently in the police records without the permission of the police. 3. The petitioner accused shall cooperate with the police investigation to the fullest extent, providing all information, documents and material that he may be called upon by them to provide. He shall not influence witnesses or cause directly or indirectly the destruction or disappearance of any material as may be felt by the police to have evidentiary value. The surety shall be a permanent resident of Aizawl, duly certified to that effect by the chairman of the local area council concerned. The surety shall, in addition to the certificate of the chairman, put up as security for bail his own land settlement certificate, which must be, in the opinion of the court, of the same or greater value than the bond amount. So, my lords, these are the conditions which have been set. Your lordships, in a similar matter, my first submission is this, that apart from the general principles governing the bail conditions which are onerous, my lords, in a similar matter, one of the co-accused has already been granted similar relief in criminal petition. I'll just pass this on, my lords.
He was also granted bail and
Bail
what was
and
the bond?
onerous condition of 45 lakhs was given.
Acha,
That has been set to a bail bond amount of 2 lakhs.
acha.
Yes, my lords. Your lordships would see this is Madhurya Sarma. He's a co-accused. I'll take your lordship straight to the relevant paragraphs. My lords, at page number 4, this honourable court by a coordinate bench had, my lords, extracted the bail condition at page 4, second paragraph in the middle. The petitioner, namely Dr. Madhurya Sarma, during the course of investigation was granted bail by the Court of Learned Additional Sessions Judge, vide impugned order dated 13 June 24 on furnishing bail bond of 45 lakhs with 2 sureties. This, my lords, after this honourable court had taken note of the relevant judgments of the Honourable Supreme Court, had modified it at para 14 at page 10.
Yes.
In the result, this court finds sufficient merit in this petition and accordingly the same stands allowed. In the given facts and circumstances on the record, the condition of executing a bond of rupees 45 lakhs stands modified to rupees 2 lakhs. Now the petitioner has to execute bail bond of 2 lakhs with 2 sureties of like amount. However, the remaining conditions would remain the same. my lords, we are seeking parity. And even if your lordships could even exercise your lordship's jurisdiction to a bail bond which is even lesser than 2 lakhs, it would be practical for the accused. It is understood that, my lords, he is the prime accused. But, my lords, even in this order by this honorable court, it has said in the preceding paragraphs that the charges are not yet proved. And he's been in incarceration for some time, my lords, more than a
Charge
year.
sheets have also not been submitted? No.
My lord, charge sheets have been submitted.
Oh,
Yes,
charge
ma'am.
sheet submitted?
Yes, Miss. Ma'am.
Charges framed or no? Not?
Charges have not yet been framed, my lords, because of the quashing petitions which are still pending. So, your lordships, this is our case. And, my lords,
Madhurya Sharma is also an accused in the same case?
yes, same case. He is the car dealer.
He is the car dealer.
And
And Jakir is the employee.
employee, business head of the Mahindra here in Mizoram, my lords.
Jakir.
Jakir Hussain.
Acha, acha.
Yes, my lords.
He is the business head of
The
Mahindra.
Mahindra complainant itself.
In this state.
Yes. So now, your lordships, this is the order. We have annexed the charge sheet also to show that, my lords, the investigation is complete and the charge sheet has been filed. It is at the stage of consideration of charge, as your lordships had asked, if charges are framed. And, my lords, we have also put, my lords, his voter ID at page 200 of the petitioner today. Jakir Hussain, my lords,
Where is that?
at page 200, annexure 4.
Yes.
His permanent address as such, my lords, it is in Tezpur, Sonitpur, my lords, in Assam. Similarly, my lords, even the permanent address of the co-accused Madhurya is Assam, but still he's been granted. Till now, there's no violation. All of them are coming. In fact, my lords, there are around 22 to 26 accused. Only about two are incarcerated. All the others have been released. Another prime accused, who was the former business head, called, my lords, Yogesh Sarda, he has also been released. All of them are coming duly to the courts, attending trial, my lords.
Conditions are not violated.
And conditions are not violated, my lords.
In
Only
fact,
I have,
the bail was granted on what ground?
my lords, here,
On merits or what?
my lords, some of them were granted due to default bail under 167.
That is okay.
Yes.
What about Jakir?
In this particular, my lords,
You have annexed a bail order?
yes. Page 24, my lords, it starts.
You have to annexed a bail order.
Yes.
24. Okay. On what ground?
This, my lords, on
second FIR?
yes, my lords, this is the second FIR. C and
No,
EO.
bail was granted on the ground of non-maintainability of second FIR. No.
My lords, even though there is no elaborate discussion, it seems this has been made on merits. Because your lordships at page 29,
The petitioner is under arrest in 2 separate cases, altogether 3 cases.
3 cases, all granted bail by the lower courts, my lords.
In all the 3 cases?
Yes.
This is in respect of one. In the other 2 cases, 50 lakhs.
Other 2 cases also, my lords, in basically, my lords, the first FIR is Azol PS 96.
Acha, Aizol PS 96.
Yes.
Okay, then
There-
24.
There, my lords,
24.
24 as it, my lords.
No, the year.
The year of the FIR,
Uh-huh.
24, my lords.
24. Acha. So,
Here,
one is 96 of 24, then?
my lords, then C and EO number 3, which is the present petition, my lords.
Acha. This is CID case
Yes,
of 3.
3.
Okay. Okay, 3 of 24. Then the other one,
CNEO number 5, CID.
CID 5.
Yes, my lords.
This is in respect of CID 3.
3. My lords, the learned ASJ, the Sessions Court, had not only considered the merits but the relevant factors which can be seen from para 29, page 29. And your lordships will come to
Wait,
page
I-
28 actually.
uh,
Page 28 would be.
I'm going through one by one. 27. Key person to defraud. Then Amit Bhai Anil Chanda. Fresh cases only. That was the main ground taken, I think.
Yes, my lords.
Fresh
And
cases to be registered on the same facts and connected facts,
167. my lords.
which could be the subject matter of which tend to allow the investigating officer. And the filing of the second case has extended the possible police remand period. But second FIR is always not unmaintainable. I mean, if
Yes.
graver offences is made out,
Yes, yes.
so
It is true, my lords.
by another 15 days, acha, police remand period will then again
Yes,
increase.
yes. That had been violated.
The investigating officer has already availed 15 days period. In connection with this case, the fact is not disputed. Okay. The been in custody for a total of 70 days. The policeman is arrested. Period. Acha. That was the main ground.
Yes.
Okay.
But your
Because
lordships.
if the second FIR is allowed to be registered,
Yes.
then again police remand will increase by another 15 days. Again 15 days.
Yes.
So, do you have any decision saying that on these grounds bail can be granted?
But my lords.
Depends on right,
Yes, yes, my lords.
discretion.
Discretion, my lords. But your lordships, in the next paragraphs, it had, even though it was not elaborate, the learned ASJ seems to have seen whether the relevant factors of while granting bail, that is, my lords, if the accused will flee, so on and so forth. I believe that has been taken into consideration, but
Which
without.
paragraph?
My lords, the next, as submitted by the petitioner accused, the investigating agency has already
Wait,
availed.
wait, I'm not getting it. Which? Oh
Page
yes, as
20.
submitted, yes.
Yes. As submitted by the petitioner accused, investigating agency has already availed of 15 days police remand period. They were entitled in connection with this case. The fact is not disputed by the learned PP. Accordingly, only judicial remand would now be possible in respect of CNEO 3/2024. The petitioner accused has been in custody for a total of 73 days from the time of his first arrest. It is reasonable to expect that investigation will not be hampered if the police has from his arrest in this case filed on 20th March 2024 opportunity for custodial interrogation of the petitioner accused in relation to the instant case. If they have not exhausted the police remand period flowing from Azol PS, both cases being intimately connected, accordingly the petitioner is allowed to be.
Acha, yeah.
The problem is, yes, my lords, there is the order could have been more elaborate, but there is another Supreme Court judgment, my lords, and I'm sure your lordships is aware that there is no particular format of actually granting bail orders.
Oh
my lords.
yes, this is on discretion of the Honorable
Yes.
Court. Now you are only with the onerous condition.
Yes, my lords.
Now, of course, these conditions also depends on the facts and circumstances. What will be the bond, what
Yes.
will be the conditions, right?
Yes.
Now he is the employee
Yes.
and he is the head of the business concern here.
Yes.
Okay, then what else on
My
this?
lords, I'll just show your lordships some few judgments. That is all, my lords, because there's nothing much to say. The bail has been granted.
What about the other papers? It's a very huge this thing.
My lords, we've only put the chart sheets and everything. This is the chart sheet.
This is the charge sheet
Just
and
to
it's a
show-
3.
Yes,
Oh, in respect of all, so this is a big charge sheet.
big charge sheet, my lords.
Okay, then
Thereafter, my lords, we put,
152 is also a charge sheet.
yes. My lords, original charge sheet was submitted and
Ah.
thereafter supplementary charge sheet was also submitted.
173.8.
Yes.
And then, and then your
And then
address
my
proof
voter
and all.
ID, my lords. And the Aadhaar card of my family. I mean my wife,
Ah,
my elder son, and birth certificate of my daughter.
And the judgment of the coordinate bench you have annexed here.
Yes.
Yes, annexure 5.
Yes, yes, my lords. It's already there.
Okay, let me see the judgments then.
Yes, my lords. My lords, I'll be first quoting. This is, my lords, in Girish Gandhi versus State of UP, 2024, Volume 10, SCC 674.
This is by Honorable Chief Justice Gavai.
Yes, my lords. This is Gavai and Justice Vishwanath. My lords, at para 25.
These are differently binded here. I mean, in our Guwahati, the binding is different. I was wondering whether it's an SCC book. Okay. So, yes.
My lords, para
Uh-huh.
25, if I may read.
25, yes, yes.
From time immemorial, the principle has been that the excessive bail is no bail. To
This is
grant,
what I was talking of, I think.
yes,
To grant bail.
to grant bail and thereafter to impose excessive and onerous conditions is to take away with the left hand what is given with the right. As to what is excessive will depend on the facts and circumstances of each case. In the present
It depends
case,
on facts and circumstances of
yes,
each case.
yes.
So, what is the criteria for bond? Anything more stated?
My lords, this is on basically sureties, but I will take your lordships to
Sureties are sometimes difficult to find. What
Yes.
about bond? The money.
yes, yes, my lords. This will be, my lords,
Yes, bond is.
my lords, in if I may,
paragraph 20.
yes,
Bond is quoted, section 441. It was not elaborated. on
yes,
bond.
my lords. In this is insofar as
Go
the
on, this.
sureties,
Ah.
but if I may refer to 1978 judgment in Motiram,
Okay.
this is specifically on bail amount.
1978.
1978 for SCC 47.
This is an onerous condition, so I'll put
Yes.
this is yes. Then, huh.
Here, my lords, we are referring to para 30.
If sureties are obligatory,
My lords, I believe sureties is the My lords, by the language of 441 in the CRPC, it seems
give me see.
it is a natural
I have to
corollary.
have it. It's a yes. just go through 441 once?
Yes.
Amount of bond and reduction thereof. With due regard to the circumstances of the case and shall not be excessive. This is what it is.
Yes.
It is a discretion of the court.
Court.
The High Court or the Session Court may direct that a bail required by a officer may be reduced. So anything in Motiram about 441?
Yes, my lords. In Motiram, at para 30.
Para 30, okay. If sureties are obligatory even for juveniles.
If sureties are obligatory even for juveniles, females and sickly, if during trial when the presence to instruct lawyers is more necessary, my lords, bearing in mind, my lords, para 32 is what I am trying to get your lordships at.
Achha. It shocks
One's conscience to ask a mason like the petitioner to furnish sureties for 10,000. Magistrate may be given the benefit of doubt for not fully appreciating that our constitution enacted is meant for the butcher, baker, candlestick maker. Shall we add the bonded labor? My lords, this is a little different. But ultimately, my lords, the principle
The consideration that went into the mind of the Honorable Court is what I think is because of the gamut of the
correct.
conspiracy or
Yes.
embezzlement.
Yes.
He had done it 50 lakhs.
Yes, yes, my lords.
Because so much of money is,
Involved.
yes.
Yes.
Because of the gamut they did it. But if he's not able to come out because of that, that
Yes.
will not be again doing justice.
And my lords, your lordships, this order is passed in June of 24, the bail order. We are already, my lords, in today's 12th of June,
When was the bail order issued? You just said what date?
10th of June 24.
10th of June
Yes.
24. And the other bail orders?
My lords, in the first FIR, he has been recently been granted. There a bail bond of 2 lakhs has been given.
And this bail is granted when? Recently you said?
22nd May of 25, if I'm not wrong. 22nd May, I'll just cross check.
22nd May 2025.
Five.
So very recently.
Yes.
But because he is inside for the other cases, so he was not able to come out.
Yes, yes, my lords.
So it's not only on the bond issue.
Yes.
And the other one, there are 3 cases?
Yes, in the other one, my lords, that was granted on yes, my lords, 15th of October 2024.
Acha. Now he is out in these 2 cases, he has been able to furnish bail bond, I guess.
No, my lords. This, my lords, this is the second matter
Huh?
which is coming at item 12.
Acha. There?
So there also we are seeking these conditions be altered, my lords.
There, how much bail was, bond was?
50 lakhs, my lords.
Same,
Same.
50 lakhs.
Yes.
And the third one? Not
And the
much. Oh, 2 lakhs.
2 lakhs, my lords. Bail bond.
Acha. Same FIR almost, all the 3.
My lords, most of them are, yes, these 2, Azol PS, the first FIR, and the second CNEO3. These are, my lords, we are seeking that the allegations are ad verbatim. That's why the squashing petitions have come up. Insofar as the last one, it was made by a private complainant. It was slightly different, but it is interconnected with the same cause of action.
Second one is by Mahindra.
Second one is by Mahindra. First and second is Mahindra.
Third one is by some other complainant.
Yes.
But the cause of action is same.
Cause of action is same. Interlinked, my lords. These are.
Of course, while quashing of the FIR, we'll have to see the sameness of facts.
Yes, yes.
What do you say, same? There is a concept given in, I think, T.T. Antony also.
Yes.
The test of sameness.
Test of sameness, yes, my lords. The lordships is right.
And what else? What are the other judgments?
My lords, I am referring to. I have
Motilal, you are referring to paragraph 30 and 32.
My lords, 32.
Motiram.
Yes, Moti Ram.
Then,
And my lords, there is this recent this judgment of 2024 volume 10 SEC 685. This is policy strategy for grant of bail.
oh, this is, no, the other one. Oh. 2410-6, okay.
24 volume 10
Huh.
685.
Yes, 674,
685. my lords.
85, yes, now, yes.
My lords, I'll take your lordship straight to para 9 of this. Para 9 it says, with the view to ameliorate the problems, a number of directions are sought. We have examined the directions which we reproduce here and after with certain modifications. I'll take your lordship straight to sub para 6. If the bail bonds are not furnished within 1 month from the date of grant of bail, the court concerned may suo motu take up the case and consider whether the conditions of bail require modifications, relaxations.
Okay.
7. One of the reasons which delays the release of the accused convict is the insistence upon local surety. It is suggested that in such cases, court may not impose condition of local surety.
Okay.
And my lords, again, I come back to the coordinate bench's judgment. It has cited 2 relevant Supreme Court judgments. One is, my lords, Sandeep Jain versus National NCTD, reported in 2002, SEC 66. One is Sumit Mehta versus State 2013, 15 SEC 570. I'll read out from Sandeep Jain, my lords, at page 214 of the paper book, or from the internal page 8 of the order.
Sandeep Jain.
Sandeep Jain. We are unable to appreciate even the first order passed by the Metropolitan Magistrate imposing the onerous condition that an accused at the FIR stage should pay a huge sum of rupees 2 lakhs to be set at liberty. If he had paid it, it is a different matter. But the fact that he was not able to pay that amount, and in default thereof he is to languish in jail for more than 10 months now, is sufficient indication that he was unable to make up the amount. Can he be detained in custody endlessly for his inability to pay the amount in the range of 2 lakhs? If the checks issued by his surety were dishonored, the court should perhaps have taken it as a ground to suggest to the payee of the checks to resort to the legal remedies provided by law. Similarly, if the court was dissatisfied with the conduct of the surety, as for his failure to raise funds for honoring the checks issued by him, the court could have directed the appellant to substitute him with another surety. But to keep him in prison for such a long period, that too in case where bail would normally be granted for the offence alleged, is not only hard but improper. It must be remembered that the court has not even come to the conclusion that the allegations made in the FIR are true. That can be decided only when the trial concludes, if the case is charge-sheeted by the police. Para 12, my lords, the coordinate bench says, thus proposition of law which can be crystallized from the cases discussed herein above is that courts, while granting bail, ought not to impose onerous and excessive conditions, else it would tantamount to refusal of bail, and it affects the rights guaranteed under Article 21 of the Constitution of India and amounts to denial of justice. The words any condition used in the provisions should not be regarded as conferring absolute power on a court of law to impose any condition that it chooses to impose, and the words any condition has to be interpreted as a reasonable condition, acceptable in the facts, permissible in the circumstances, and effective in the pragmatic sense, and should not defeat the order of grant of bail.
Yes. Where are the pleadings that because of this onerous condition you have not been able to come out? There are pleadings, right? Where?
My lords,
Specific.
specific pleadings, my lords. My lords, at grounds B at page 6
D,
B.
B.
For that, the condition of furnishing a bond of rupees 50 lakhs duly guaranteed by a suitable surety is totally excessive, arbitrary, unreasonable, which is beyond the means of the petitioner herein.
Okay.
My lords, apart from the condition of 50 lakhs, we have also sought for the alteration of two more points.
Condition also?
Yes.
What are those?
My lords, one is that I have to report every day at 9 a.m.
Yes.
because, my lords, the charge sheets have been filed.
Huh.
Investigation is complete. If it is once in 2 weeks or once in a week, that is manageable, my lords. But every day at 9 a.m. and now that my bank accounts have been frozen, everything is frozen. Even the state cannot deny this fact, my lords. I do not have any means. Actually, if I go out, I'll be living the life of a destitute, my lords. I was living in a rented place in Mizoram while I was working as an employee. And that landlord has also thrown me out from that particular, my lords, from that house.
Landlord had called you up saying what?
My lords, the tenant agreement which I had with my landlord, that has been, my lords, now cancelled because of this criminal case. So my family today also, my wife and 2 kids, they are now settled in Assam. They've gone back. They were living with me here. So there is also a problem with this because here, my lords, at the condition number 2, the learned ASJ has
Shall-
also asked me to, my lords,
Not to leave
not to leave.
or relocate his address
Yes.
presently.
If this
So
could
he
be,
has to be here.
my lords, this, yes. If this could be changed to the effect that if I take the permission of the court, because the police, my lords,
Normally the condition is that he should not leave without the permission.
of the court, but
Of the
here, my
court.
lords, it said the police. This is a issue, my lords, because the complaint,
These conditions are before charge sheet or after charge sheet?
my lords, in this particular case, 10th of June is the
Huh.
bail.
Yes. Then
This was
charge sheet?
pre-charge sheet.
Oh, so pre-charge sheet, so
Yes.
the conditions are there.
Correct, my lords.
As such, they are not wrong as far as
Yes, at the time.
now that the condition has changed.
Yes.
Only 1 and 2. Then 3, okay, you will cooperate and all.
Yes, my lords, I will cooperate. In fact, in the charge sheet, what it reveals is, my lords, that there are around 70 plus witnesses. Most of the evidence, the prosecution's case is built on documentary evidence mainly, because the movement of money is the main scam that is alleged. So, my lords, I cannot in any way tamper with these. They've been collected, charge sheets filed.
These are your submissions?
This is it, my lords.
Yes.
Lordship, in the meantime, my lord,
No, yes, 1 second. Huh? You are for,
for Mahindra, my lord.
you are for
So,
the,
my
let the
lord,
PP submit first.
Yes. Before that, my lord,
Huh.
now since this is the first time, number one, number two, Mahindra is not pleaded as a party now, so I cannot say anything herein. And
Oh, you are not made a party here.
no, my lord, that's the problem. And another thing, my lord. Now, in the item number 3 today, my lord, the same
Oh,
matter
yes,
has been
you are
challenged, my lord, by Mahindra, saying that the bail order has been challenged in that petition, my lord, filed by Mahindra. So that, in the meantime, now, if this matter is taken up and disposed, my lord, it will all be infractuous. my
No,
lord.
no, no. My
So,
lords.
my lord,
No, I don't
Let
think so.
all-
Infractuous, these are.
infractuous in the sense, my lord, that now since this condition, my lord, there, oh no, actually not infractuous, but there will be greatly prejudice, my lord. So my prayer, my lord, is that since today is only the first time, my lord, so let all be taken up together at one go, my lord, on the same day, my lord, along with
This is
item number
only
3.
on conditions, so what role you have to play?
That is why, my lord, I would like to make submission hearing in the, now, since in the coordinate bench order, my lord, my learned friend has shown to your lordship. They are completely different, my lord. In that case, it's only car dealers. But now today, he is the prime suspect, my lord. He's the prime suspect, as he himself had submitted, my lord. My land has submitted. He's now not living within the state, my lord, and even his family
not-
has all moved down to some other state. So
His
there
family
is-
can move, but he is here, right?
His custody, my lord.
Oh, yes, he is
Once,
inside.
my lord, once released, you'll all go down outside state, my lord. So, completely different, my lord, from that case which my land has referred to. So, my prayer, my lord, is that let all the matters be taken up together at one day, my lord. So, that's my prayer. And the Mahindra, my lord, if the court permits, would like to make some submission hearing also, my lord. So, for that, my lord, we'll have to afford some time, my lord. Now, we are not a party hearing. And since this is the first time, my lord, before he launches.
But that is a point, like he has some, because complainant is Mahindra.
My lords.
So this,
Greatly prejudiced, my lord.
without hearing them,
My lords.
and what does the PP say?
No, my lord, this has come up for the first time. So if notice can be issued and then it can be taken up all together with the other items because it's all connected. That will be better.
No, why I decided to take up, because on one submission that he is not been able to come out because of this onerous condition. Right. And this is again not doing justice because bail is granted and he is not able to come out. So on that basis, I have decided to take it up. But again, if Mahindra has something to say,
Yes.
and this is the first time, they are not made party also.
My lords,
What do you
can I-
say as on reply? in
My
reply?
lords, if I may pass this order. My lords, this was an IA filed by Mahindra because we did not implead Mahindra in the coordinate benches order, my lords, which I've shown, where we had sought quashing, alteration of the bail conditions.
Yes.
There also, my lords, we did not implead Mahindra. They filed an application, this IA 30, wherein they said, implead us, we also should be heard.
Where what?
They
This I is for what?
impleadment, my lords,
My lord. Then
and assisting the public prosecutor. My lords, there, the learned, this honorable court had said on a reading of 301 of the CRPC, which is appearance by public prosecutor,
His duty is only to assist.
to assist. I do not object to his assisting, my lords. In fact, that the other matter in item 12, there, my lords, the order passed, the second order which had been passed, they had said that it is a matter of liberty, therefore they should be heard and no adjournments would be, my lords, allowed. Passed by Justice UK Nair, my lords. So, my lords, all I'm saying is, I have no objection without an application to assist the PP. But, my lords, the liberty today is at, my lords, he's been done great injustice, my lords. Liberty is at stake. So, my lords, to push it forward, and my lords, the issue is, the law is very settled, so far as the conditions being onerous and so
Yes,
forth.
law is settled, but then there is a prayer by PP also that
Yes.
she has to be put on notice. And if he wants to assist the PP,
Yes.
there also I cannot deny him.
My lords.
So one thing we can do, today I'll issue notice and let him be impleaded as a party respondent and he can assist.
my lords.
And then he can take it up next week,
Thursday, my lords, as your lordship said.
Tuesday or Thursday.
Seems problem again, my lord. Now, as in the rest of the matter, my lord.
Oh, you want the entire matters to be taken up today?
My lord, at one go, my lord. That's
My
all.
lords, my
So
liberty.
let's have it on Thursday next, my lord.
No, Thursday next, entire matters cannot be.
That's why. Then Tuesday next to next week, my lord. Tuesday, 24th of June.
My lords, I have great objection. If it can be taken up on Tuesday, I have no issue, my lords. The issue is so small, my lords.
It doesn't matter. Only 1 week, my lord. Now
My lords, for them it would not matter because they are not in jail, my lords. I am.
they've all now been this long, my lord. So only 1 week, my lord, is the difference. Either my prayer, my lord. That's why my prayer is to take up all the Mahindra matters next week, Tuesday or Wednesday. That's my main prayer, my lord.
Otherwise, item number 2 is not tagged, right?
It is
Item number 12, you can have the prayer that everything should be taken up together.
But it's Mahindra, my lord. So, so it's very convenient to take all the matters of Mahindra together, my lord. Very convenient, even the our lordship also.
But then this issue is totally different from the
In the
quashing or cancellation or
at the same
everything.
time also. Yes, I agree, madam.
This issue, yes, you agree. See, I mean, it's
The
totally
issue
different.
is, the issue is that, my lord, that for modification of the bail condition, I see, my lord. But now if we modify it, it will greatly prejudice the case of Mahindra, my lord. So now even on the challenging the same bail order, my lord, Mahindra is also filing petition, my lord. So it is very convenient to take up all together, my lord.
But then what prejudice will be caused to Mahindra? See, he has been granted bail, but then he is not able to come out because of the conditions. After that, you file for cancellation of bail. You have already filed. If it is cancelled, he is back. Right.
So, my lord, they all be taken up together at one time. It also be convenient for the Mahindra.
Okay, right. We heard Mr. Jordan, so and so, for the petitioner in item number 2, huh?
Yes, ma'am.
So and so, and Mr. and Miss Linda, public prosecutor for the state of Mizoram. This is an application filed for modification of the conditions of bail, which to reduce the bond, reduce the bail bond, you say, right?
Yes,
To
ma'am.
reduce the, where is the application? What, to, wait. To reduce the bail bond from rupees 50 lakhs to a lesser amount, as well as modification of the condition that he may be allowed to go outside the jurisdiction of SPCID Aizawl with the permission of the court, as well as the condition that he may be allowed to appear, to report to the court once in a week, or what you said?
My lords, it was actually to report before the police
Huh, but then that has to be again,
Yes.
charge sheet is submitted.
submitted. So, my lords, in fact, we are seeking that this condition may be set aside as such.
Huh. As well as for setting aside the condition that he should report to the Crime and Economic Offences PSCID every day at 9 a.m. The council appearing for the Miss Linda appearing for the state of Mizoram, however, stated that notice may be issued at this stage and the matter to be taken up together along with other analogous matters where the complainant where the accused persons had filed, had prayed quashing of FIR, cancellation of bail, as well as for other reliefs. She also submitted that the complainant is also not made a party in the instant application. Stop. Notice be issued to respondent number 1. As Miss Linda appears for respondent number 1, do you want extra copies or you don't want? Oh, you already have.
Yes, Your Lordship, we already served.
What did I say? Notice to be issued to respond number 1. No extra copies is required to be served upon her. However, the petitioner is allowed to implead the complainant as respondent number 2 in the instant petition by filing an appropriate impleadment petition. Let the matter be listed on item 2 on coming Tuesday.
My lords, if I may seek one thing, my lords, seeking the impleadment would be an issue. In fact, if the order could be that I would, since on his appearance for the counsel for the complainant, I have no objection to them assisting the PP.
No, actually he cannot appear because
Yes.
he is not made a party.
That's,
He cannot appear, so I did not reflect his name and all.
yes, yes.
But you file an application by today,
My lords, I'll try. I'll
right?
do that.
By hand it is not allowed nowadays
Yes, yes, yes. My lords.
because you have to file an application. I'll allow it if you file it today.
My lords.
I'll allow it tomorrow and then Tuesday we can hear, or Thursday. Thursday
Yes.
will be better.
My lords, Tuesday, my lords.
Achha.
Again, Thursday, the other batches will come.
Ah, okay.
I'll
So
file it
let-
by today.
Let the matter be listed on Tuesday. And what about 9 or would the other matter
12.
12 is again tagged. So,
Your lordships may detag it and hear this on Tuesday with this petition, my lords. There they've been a party. This was actually handled by a previous council, my lords. They've been made a party there. And the order of Justice Nair is there, my lords, which said that no adjournments may be heard.
and write in item number 12. See, because it is for interest of justice what I am doing here, because this is totally a different issue.
No, my lord, now,
And there
regarding
will be
this-
conditions. He cannot leave.
that, I agree, madam, I agree.
Huh.
But now regarding item number 12, madam, this is regarding, you have a mistake, is regarding quashing, isn't it?
No, no,
No.
Modification.
Onerous condition in respect of the other case, where again 50 lakhs bond is provided for.
Okay.
In item number 12, you write, heard Mr. So-and-so, you write this. Thereafter, you say that although this instant petition is tagged along with criminal petition 1 of 2025, the issue, however, is different inasmuch as the petitioner has prayed in criminal petition 2 of 2025 for modification of the onerous condition of bail. Full stop. Or not full stop. Whereas the other criminal petition, 1 of 2025, is meant for quashing. 1 of 2025?
Yes, that is for quashing.
1 of 2025 is for quashing of the FIR filed against the accused person, filed against the petitioner. As such, for interest of justice, this court detaches the criminal petition 2 of 2025 from 1 of 2025, and since the issue is similar to item number 2, that is criminal petition 16 of 2025, let this criminal petition, that is 2 of 2025, may also be listed on Tuesday, along with 16 of 2025. Okay? Okay?
Grateful, man. Extremely grateful.
Lordship, regarding the rest of the Mahindra matters, my lord.
Those are fixed on 24th.
Thursday.
24th, yes.
24th.
Obliged.
24th.
There are other matters from part 2? No. Part 2, that matter is adjourned. What was? Tomorrow, Friday, I'll pass. Okay. There are no more matters, so
My lord.
I'll dictate orders. Okay.